This divorce should have been simple. No kids together, no massive asset fight, no complex custody battle. Instead, we've got a nearly 30-year-old truck, a prenuptial agreement, allegations of a restraining order, and two people who clearly cannot stand each other. One side says the truck was separate property. The other says it was a gift. The judge is already frustrated because this case is past the 6-month timeline, and somehow this old pickup is holding up an entire divorce. The real question is this about money or is this about control? Let's get into it.
He literally makes $280,000 a year. I'm a single mom working for $16 an hour. Like, why do you have to be that petty?
Because that's how they are.
Yeah.
I'm just saying.
Okay, this is 24S3145D. This is Cooper and Cooper. Mr. Hess, you represent plaintiff. Says the date and time scheduled for a final settlement conference. Mr. Hess, where are we at?
Your Honor, we've had some discussions. Unfortunately, we've not been able to settle the case. One of the key issues in this case, my client, his position is that this truck is his separate property pursuant to a prenuptial agreement. The defendant has her own perception of what should happen with the truck. I did get an ex parte order signed by the court on March 18 that specifically prevented this truck from being sold, as well as a general restraining order against disposal of assets. My client received information thereafter that the vehicle had been sold. The defendant has not confirmed this, but she hasn't given me any information as to whether the vehicle has been sold, the price, to whom, etc. So I did send out some discovery to her on April 9. So she would have had she has 28 days from April 9 to answer it. And that's where we're at.
All right, so when was this filed? How old is this case?
October 28th, it was filed, 2024.
So it's a DO. So the Supreme Court says these should be concluded in 6 months. So November. So we're already past the 6 months. Could I ask, and either one can volunteer an answer, why we are fixated on a truck that's almost 30 years old? Why does anybody care about a 30?
Right here, the judge is doing what good judges do, cutting through the noise. Courts operate on efficiency. When a case is dragging past statutory timelines over an aging vehicle, that raises red flags. The Supreme Court guidelines say these cases should move within 6 months, and we're already past that. So the judge is essentially asking, is this really about value or is it about leverage? Because in divorce litigation, old assets often become symbolic weapons. And when something isn't worth much, but both sides refuse to let go, that's usually not about the truck.
Year-old truck.
I had bought that pickup and I had not put it in my name. And then when the time came to plate it, I had asked my wife.
All right, I'm gonna stop my client. I guess the point is my client believes it's a separate property, and it is specifically listed in the prenup as his. So he does want the truck. I mean, there's been discussions about, okay, if he doesn't get the truck, what is the value? What should he be paid? So we have talked in those terms as well, Your Honor. And
well, then I just got to ask, Ms. Cooper, what do you care about the truck for? You often drive F-350s that are from 1997.
Well, the prenup that I was asked to sign upon our marriage was very clear, out of protection for him. I believe that he's fussing about it because the prenup ended up protecting me more than it protected him. What comes down
he's
to,
saying he wants the truck.
right?
Give him the truck.
I don't have the truck. I sold it prior to receiving that motion. It was sold and gone way long prior.
Now this is where things get legally dangerous. There was an ex parte order preventing the truck from being sold, plus a general restraining order on disposing of assets. If the truck was sold after that order, that's a serious issue. But if it was sold before, timing is everything. Courts don't care about feelings. They care about dates, filings, and proof. And notice she says she could not see when all that occurred. That uncertainty is exactly why discovery was sent out. Because if that sale violated a court order, that could shift leverage fast.
To it.
I could have to see when all that occurred, but that could be problematic.
I'm willing to wait it out though, because the prenup is very clear legally that any gift from him to me belongs to me if divorce were to happen. It was a gift, hence why it's in my name. That's how it got into my name. So my belongings that he has aren't worth to me to just give up. So if he wants to take this all the way to the end, we can stay married for as long as he would like, or we could just be done
So
with it
the
today.
idea was he's got some stuff you wanted, so you'll sell his truck and he can keep your stuff. I mean, is this
If
kind of a
that's, if
tit
that's
for
how he
tat,
would like to end
sort of
it,
petty?
if that's how he would like to end it, that's fine. I would like to just be divorced if we could just get that part over with. The truck isn't worth any substantial amount of money.
Well, I'm guessing that's why I'm asking both sides here.
my
Why are we
MacBook
fighting
that
about
he
a
owns-
30-year-old truck?
My MacBook that he has is
Worth
equal
more than his
to.
truck, right?
Yeah,
That's
but the
what you
truck's
wanna tell me?
gone and there's no getting it back, so we can settle it however.
So are you willing to let him keep the MacBook?
Sure.
There
Sure.
you go, counsel. I think we've worked it out.
So can we please be divorced?
I
He can sell the
mean,
Mac.
she
the
had
MacBook.
provided,
Go get a different truck. Get a newer truck. Or maybe a boat. It looks like he's in some tropical place right now with, can't tell if that's a tiki hut or what.
Or maybe you make $280,000 a year and you could just go buy a new one.
I don't know.
If
What do you
what it-
think, counsel?
well, he doesn't make that kind of money to my knowledge, but you know, I'm happy to resolve this if we can. You know, but the truck is worth, my client believes, $10,000 to $15,000. I mean, the offers that we've received are less than that. The stuff that she has at my client's house, he's more than willing to give that back as part of a settlement. But I guess I'd want to talk to him privately if you know he wants to, as to what he wants to do here.
You want me to put you in a breakout room for a minute?
That'd be fine.
Okay, and then you should, don't hold me to this, you should be able to take yourself out of the breakout room when you're ready to come back in.
Okay.
And then I'll just have staff let me know, and then we can go from there. If we can't make progress today to get this wrapped up, I'm gonna give you a trial date very quickly because it should have been done by now, and then we can just have a trial. So let me, I guess, did we get rid of our breakout? No, we all have our breakout rooms here. So counsel, I'll put you in there right now, and then hopefully you can get yourself out. If not, I'll check on you in a few minutes, okay?
Okay. All right. Thank you, Honor.
Do you love watching these things every day?
No, no, mine cost me $10,000 to pay him, and everything was my prayer.
If
I
that's
should
what,
have done-
if
I
that's
should
what
have
it
done
comes
everything,
down
but
to,
you know what I said, you know, I'm not gonna let him get a portion of my home that I bought 10 years prior to us getting together.
right?
I'm just not doing it, and it's worth $425,000. And I said, I'm not giving him equity of that.
Now listen to the emotion here. She's framing it as petty, especially with the income disparity being thrown around. But here's the legal reality. Income doesn't automatically determine property rights in divorce. If the prenup clearly designates something as separate property, that matters more than who earns more money. However, negotiations aren't just legal, they're strategic. When one party feels like the other got everything, resentment drives decision-making, and that's often what keeps cases from settling quickly. Let me ask you, if you believed someone was nitpicking out of spite, would you compromise or would you dig in deeper?
When I've paid it all this time,
Right, I know.
you know. We're back out again.
No, okay.
For his defendant to decide.
Good afternoon again, Your Honor. So my client has two options that we'd like to present. I guess option one would be that he pays, or that Ms. Cooper pays him $7,000 for the truck, and she can have the stuff back that she has indicated on a list to me. Or option 2 would be that my client gets the crossbow and the rangefinder that's currently in Miss Cooper's possession. He keeps all of her stuff that is with him. Basically, they each, other than that, they each keep their own stuff, any debts in their own names, etc. And there would be no cash payment for the truck.
All right, Ms. Cooper, you, option 1 or 2?
I respectfully decline both options.
She doesn't like option 1 or 2.
Okay. Yeah, I think we may be stuck. I mean, my client indicates that he has a trailer that was set up to pull this particular truck. The truck bed itself, he paid $8,500 to add that, and another $3,500 in transmission work. So it's just, he's offering to give her stuff back and only take $7,000 for the truck. So I don't know. I think we may be stuck.
Hey, Jane, do you have my calendar there?
Mhm.
I need a trial date. Counsel, how many witnesses do you think you need for trial?
It is likely to be my client and probably just 1 or 2 more at most.
Okay.
So the
How about
party-
you?
Same amount.
Give me 2 hours.
If we go into the lunch hour, we could do 10:30 on Monday the 5th. Is that too soon?
May 5th?
Yeah.
No, I don't think so. Counsel, May 5th?
It's probably a little too quick. I mean, her discovery isn't. She's got. I would like to have my discovery back. I sent it out on, I believe April 9.
Excuse me, can we do the breakout room one more time?
Was there a deadline for the discovery?
Well, she'd have 28 days to answer my discovery. I found out the truck was apparently sold and sent it out on, I believe I sent out my discovery on April 9. Let me make sure. I'm sorry, I sent it out on April 11.
Okay. So 28 days after April 11th. Let me see here, April 11th. That puts us about May 9th. All right, and then Mr. Cooper, you said you want to talk to your attorney? You're muted, Mr. Cooper.
Yes, please.
Okay, I'll put you guys in a breakout room again, and we don't really, let me see here. My next thing was cancel. So I've got until 2:30. So we'll give you a few more minutes here and we'll go from there.
Thank you, Your Honor.
All right, thank you, Your Honor.
Just a second, and we'll go off the record again.
I think it would have been cheaper if I would have not hired an attorney and just did it myself.
I just, the petty part is on him. I'm just the one holding it out. Like, he got literally everything.
Right.
Vehicles, house, camper, boat, like, let the truck go. Let's just get divorced.
Right.
You literally, like, he literally makes $280,000 a year. I'm a single mom working for $16 an hour. Like, why do you have to be that petty?
Because
This off-the-record moment reveals what's really fueling the conflict. She feels financially outmatched and emotionally exhausted. He feels the truck has value, especially with added upgrades and sentimental attachment. But here's what viewers need to understand. Courts don't award assets based on who feels more wronged. They apply contract law, property division statutes, and any valid prenuptial agreement. Emotional imbalance doesn't override written agreements. Still, perception drives negotiation, and sometimes the cheapest resolution isn't about who's legally right. It's about who's willing to stop paying attorneys first.
that's how they are. I'm just saying.
Seated, and let's get the camera back. Okay, so now we are again back on the record. Cooper and Cooper, Mr. Hess.
All right, well,
Anything new?
yes, we'll try again, Your Honor. So, my My client is willing to do a walk away at this point, where each side would keep the assets in their own possession, their own debts in their own names, etc.
Cooper,
Can agree.
that works for her. So to save everybody time and effort and potentially more money, Mr. Hess, can you get that reduced to writing? And if you want to email it, we can have you folks sign and she can stay here and sign on her end.
I have a quick question, sorry.
Mhm.
There's one thing. Sorry, I completely forgot about it, but one thing, there's a tote in the basement that just has my children, we do not have children together. My children's baby books, newborn clothes, my dead cousin's class ring. Can I ask for that back? Because it's not a financial thing.
The deal is you
can't
both
sell it.
keep what's in your possession. Mr. Hess, she's looking for a tote with, I guess, stuff her kids has in her dead cousin's class ring.
What do you have to say about that, Ryan? I mean, do you know if it's there? You're muted, Ryan.
It is there, yes.
So is that okay that she have the tote and the contents of the tote?
Yes, that's fine.
Okay. Yeah, however you want to handle this, Your Honor. I mean, we could put this on the record if you're comfortable with that. Otherwise,
Yeah, I think we should put it on the record, but then I was hoping, just because I sense some animosity, often when we walk away from that, then it comes time to actually sign our names on the dotted line, and you know.
I don't know that I
So-
can. I mean, you're looking for me to draft a judgment of divorce this afternoon?
Yeah,
Okay, I'll see what I can do.
I mean, I assume that the way you talked earlier, I thought maybe you had something going already, like you had it somewhat prepared, but maybe not.
No,
Maybe
I
misunderstood.
don't. I would have to start from scratch. Yeah.
Then you're not, okay. So why don't we do this? Other than what we have already stated, is there anything else that would be part of this judgment that we haven't already placed on the record?
I would say that there'd be no spousal support for either party, and it would be forever barred.
Okay,
Each party is awarded any property in their own names, accounts, investments, retirement accounts, anything in their own names, and as we discussed, any items in their own possession, with the exception of this tote and the contents therein, which will be turned over to Ms. Cooper.
and then when can we have that turned over to Ms. Cooper, and how are we gonna do that? Maybe we should place that on the record.
What makes sense, Ryan? Within, I don't know, within 7 days after the judgment is final.
I can pull it
I
out
was
of my
hoping that
basement.
we could get the judgment in 7 days.
I can get it out of my basement tonight and have it on the curb.
That doesn't sound promising. Is there any place else that might be a little more secure you could place it?
Well, there's a no contact order between her and I.
Is that the result of this case?
The result of a domestic violence on her part, along with criminal sexual conduct.
Now the layers deepen. There's a no contact order. Allegations of domestic violence and criminal sexual conduct are mentioned. That changes the atmosphere entirely. Even if those issues aren't directly being litigated in this moment, they explain the tension. The judge senses animosity, and that's why he's carefully structuring how property like that tote will be transferred. Courts think ahead. They anticipate future conflict and try to build safeguards into agreements. Notice how detailed the logistics get. Location, timing, third-party involvement. That's conflict management in real time.
I remember this. This is the PPO case, isn't it?
Yeah.
Yeah.
we
Yeah, there's a
have
lot-
domestic violence
A
transition,
lot
both
going
have
on
contact
here.
order.
Okay. How do we get the tote?
I have a suggestion.
Yeah,
His parents, along with his daughter, go to my church, my
Uh-huh.
Kingdom Hall. he could have them bring it to a service and I could get it while I'm there. I go every Thursday evening, every Sunday afternoon.
Mr. Cooper, she's suggesting you give the tote to your parents and that they can deliver it to the service on Thursday evenings.
That could be arranged.
And then just so we're all on the same page, can it just be this Thursday tonight?
Tonight?
Yeah. What time's the service?
It's at
Well,
7.
And how far are you from your parents?
my parents are in Greenville, half an hour away, and I don't deal with my parents, so it would have to be my daughter, and my daughter is with her mother this weekend. I'm going to be south of Grand Rapids until 6, so no, that's not.
What if we just go next week would be May 1st? Can we just plan it'll be Thursday, May 1st? The tote will be in the possession of your parents who will deliver it to Miss Cooper at the Thursday evening service. Does that work for everybody?
Works for me.
And then Mr. Haas, since we're going out to the 1st, could the court have that judgment that both sides are going to sign on or before May 2nd?
I don't see any problem with that, Your Honor.
And then Miss Cooper, how can you be reached for Mr. Hess so that he can get you this document to sign?
We've been
He has my
communicating
email.
through email, so I would email it to her.
Okay, very good. So you will monitor your email frequently so that we can get this done by the 2nd?
Yes.
So the only thing I think we have left then is to take some proofs, and then obviously Mr. Cooper is a plaintiff, so I'm going to have him sworn. Before I do that, one other thing just came up in my mind, recognizing everything in this case. Miss Cooper, are you going to ask to restore your name to your maiden name?
I am not.
You want to keep last name Cooper?
I do, yes.
Okay.
I earned it with 2 years of a terrible marriage.
Well, that strikes me as odd that a whole 2 years of marriage, you'd want to keep that name forever.
Well, if Mr. Cooper would like to pay for all of the things that I will have to change and all of the hassle and going through my insurance company and my doctor's office.
How about this? Let me suggest this, because now you're going far afield. What is your maiden?
Stevens,
Stevens, S-T-E-V-E-N-S.
VENS. My decision has been thought about for a very long time. I am not changing my last name.
And that's okay, but what I was going to suggest is Mr. Hess could simply put it in the judgment of divorce. Doesn't mean you have to do it. It just means if at some point in the future you change your mind, you will have a judgment that allows you to do it. If you don't want it in there and you change your mind, then it's going to cost you a filing fee and you have to come back to the court, pay the filing fee, and then get the permission of the court to do that. So if he includes it, it doesn't mean you have to do it. It simply allows you to do it if you change your mind.
If that's what Mr. Hess would like to do, that'll be fine.
I'll include it as an option. I'll say that, yeah, I understand.
Okay.
Yeah.
And then Mr. Cooper, you raise your right hand and then your attorney will ask you a few questions and you guys will be all set. So you solemnly swear from a testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you put your hand down, and Mr. Haas, why don't you take your proof, sir?
All right, and one more cleanup question. So where is
Yeah.
this church, or what's the name of it?
Sorry, what's the
The
what?
name of the church and where is it located?
Kingdom Hall of Jehovah's Witnesses in Greenville, Michigan.
Okay. Mr. Cooper, you prepared a complaint for divorce in this matter, correct?
Yes,
And everything that was stated in your complaint for divorce was true and correct?
yes,
You did reside in the state of Michigan for the 6-month period immediately preceding your filing?
yes,
And you did reside in Montcalm County for the 11-day period immediately preceding your filing?
yes,
Is your wife pregnant?
No.
Has there been a breakdown in the marriage?
yes,
Is there any reasonable chance at reconciliation?
no,
Thank you. That's all I have.
Court is satisfied from the proofs there has been a breakdown of the marriage relationship to the extent that the objects of matrimony have been destroyed and there remains no reasonable likelihood the marriage could be preserved, and it may be ordered in the judge that the parties be divorced from the bonds of matrimony, and a judgment of divorce may enter in accordance with what has been agreed upon by the parties, along with other standard terms and conditions. And Mr. Cooper, I just want to confirm, I don't know that we had a specific question. Do you agree there's been a breakdown in your marriage relationship?
Yes,
All right. Do you agree that it's to the extent that the objects of matrimony have been destroyed?
absolutely.
And would you go on living as husband and wife if the court didn't grant a judgment of divorce?
Not a chance.
All right. Okay, then Mr. Hess, if you'd stay in communication with Ms. Cooper as you finish off that document, so to speak, and once it's completed, if both sides can then sign it and date it, and obviously that can be done electronically if that's easier. Then it just needs to be submitted to the court by May 2nd. Is that the date we gave? Or yeah, May 2nd, and then the tub will be returned by the 1st or on the 1st at that Thursday night service. We should be all set, and the parties have mitigated then the time and expense that was starting to add up, I would submit. Okay, Mr. S, anything else from your perspective, sir?
No, if for some reason I can't get a signed judgment by May 2, then I would plan to have a judgment ready and file a motion for entry.
Okay, that'd be fine, but I would assume that we can get all of that done.
Okay.
Ms. Cooper, do you have questions about anything?
I do not believe so.
All right, then you guys are all set. Good luck. Counsel, you and your client are free to sign off on your end.
All right, thank you, Your Honor.
Yep.
And just like that, what started as a drawn-out standoff over a 30-year-old truck ends in a walk-away settlement. No spousal support, each party keeps what's in their possession, the tote gets returned through a neutral third-party exchange, the judge ensures procedural safeguards, verifies residency requirements, verifies the breakdown of marriage, and enters the divorce judgment based on mutual agreement. This case is a perfect example of how divorce litigation can spiral over symbolic property, and how judicial pressure, looming trial dates, and mounting legal fees often push parties to resolution. In the end, the court didn't decide who was morally right, it ensured legal closure. So what do you think? Was this about the truck, or was it something deeper? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.